thank you for taking the time this afternoon to come to today's seminar. Just by way of background, before I start in earnest, I just think it's just kind of useful to give some context to this paper. I'm not a legal historian by trade. I'm interested in the interaction between corporate law and environmental law. So these areas don't necessarily mix. Corporate law is largely or often about limiting liability. Environmental law is often about ensuring that the polluter pays. So these areas don't necessarily work comfortably together. So one of the first things I did was to go back and look at the emergence of the doctrine of limited liability. So that was the first stage. The second stage was to go back and look at the point at which companies could become shareholders in other companies. We know the UK takes a fairly robust position on parent company liability, and the courts will rarely pierce the corporate veil unless the conditions in Preston Petrodel can be satisfied. So I thought, well, if we have this robust position, where did that come from? When did that position start? So this paper, it's a historical perspective on that point when companies could become shareholders in other companies. So I try to provide insights into when that right was first conferred. So, I mean, that an enterprise may be conducted through a myriad of companies, each comprising a single corporate group, is an accepted feature of commerce in the UK, and it has been for over a century. So we know, well, there's three basic, and these are basic legal preconditions that will have to be in place if these corporate groups are going to emerge and flourish. And they've been treated as largely sacrosanct in contemporary company law. So firstly, we have the right for one company to be a shareholder in another company. I suppose that is the essential point. We then have the requirement, or the separate legal personality is conferred to each company, with the result that company is an entity distinct from its shareholders. The third precondition that I suppose offers the structural protection towards the shareholder is the conferral of limited liability to shareholders, with the consequence that they're not liable beyond the extent of any amount unpaid on their shares. So I think what really struck me was that each of these components was introduced separately at various stages throughout the mid-19th century, over a 20-year span. They were introduced partly legislatively and partly judicially. And the important thing for me was that there was never the intention, when these were introduced, for them to be used cumulatively together to sort of legitimise this emergence of the corporate structure. We can see that from the fact, well, subsidiary, the term subsidiary isn't mentioned in the judgments until the early 1890s. Corporate groups didn't become the main form of undertaking enterprise until the 1920s and 1930s. So I think, we'll be aware, there's a vast body of literature on separate legal personality and the doctrine of limited liability. There's lots of it. But there's been very, very little analysis of this first point, this right of corporate membership. Okay? And there's been even less analysis of the closely connected question whether limited liability should be conferred to corporate shareholders. And I think this really struck me because, well, this right of corporate membership, it's so ingrained in commerce, and it lies at the heart of many of the problems that we have regulating corporate groups. So it struck me as quite strange and quite surprising that this kind of body of literature wasn't there for that first condition. So in the paper, and it's a working paper, I'm looking to contribute to the literature by elucidating the factors that led to corporate membership being accepted, and looking at the role which shareholder liability played in that decision. So, the argument that I develop in the paper is that, well, when corporate membership was first found to be compatible with companies' legislation in the late 1860s, it was done for the overriding purpose of ensuring that the companies in question bore legal responsibility for the shares which they held or which were held on their behalf. Okay, so this prevented the companies in question from avoiding liabilities associated with shares by contending that share ownership was ultra vires. Okay, so these companies were saying, well, hang on a second, we can't hold shares. It's beyond the powers of a company to do so. And the court said, no, corporate membership was compatible with companies' legislation. So I think whilst justice may have been achieved in these formative cases, the instrumental approach of the court actually resulted in them failing to foresee the wider implications of their decision. They didn't appear to recognise, and there was no acknowledgement of, that limited liability would now be conferred upon corporate members. Nor did they appreciate that they'd laid the legal foundation from which corporate groups could emerge. So I've concluded that these were inadvertent consequences of their decision, the significance of which was only realised at a far, far later stage. I suppose the thing that's most significant is, well, through the passage of time, these early decisions were acquiesced by the legislator and accepted unchallenged by the courts as authority for the far wider principle that corporate membership was permissible under companies' legislation, even where that company's legislation was silent on that matter. Okay, so these early cases legitimised the emergence of this parent-subsidiary relationship, when actually what they were doing was ensuring that these companies bore responsibility for the shares. I suppose it's important to stress, this article is not intended as an attack on corporate membership. I'm not seeking to make this not happen. That just wouldn't make sense. But I suppose what the article seeks to do is, to try to provide a better understanding of the kind of jurisprudential foundation of this right and look at what this right was intended to achieve. So what I'm hoping that can do is to inform discussion about how to approach legal questions where the corporate structure has been used to avoid liability, something which UK company law certainly permits. Okay, so I think quite a useful starting point was it's a Court of Appeal decision from 1867, and this was the first instance in English company law where corporate membership was formally contested. Okay, so prior to this case, there hadn't been any argument over whether corporate companies could be shareholders. We did have cases appearing before the courts that did concern corporate shareholders, but their ability to act as shareholders wasn't contested. What the earlier case law did, it looked at how the power had been utilised where it had been conferred by a private act of Parliament. Okay, so it wasn't testing whether it was acceptable, it was testing whether that power had been exercised ultra vires. Okay, so I suppose it would help if I just kind of clarify or just elaborate slightly on the facts, because I think that's important to the subsequent paper. Okay, so what we had a company incorporated under the first kind of true Companies Act in the UK, the Companies Act 1862. So that was Contract Corporation. And what they sought to do was assist a partnership to convert to a joint stock company. Okay, so Contract Corporation applied for shares in this new company. The shares were to be held in the names of some of Contract Corporation's directors. One director then sought to transfer his shares back to Contract Corporation. But before the share transfer was registered, Contract Corporation became insolvent, and so too did the new joint stock company. Okay, so the litigation arose from the fact that the liquidator appealed against a decision finding Contract Corporation liable to contribute to the assets of the new company. So the liquidator was disputing the fact that Contract Corporation could be a shareholder. It argued that the act of corporate shareholding, was ultra vires and beyond the powers of a company. Okay, so the Court of Appeal affirmed the earlier decision holding Contract Corporation liable, and it found that a company could be a member of another company if authorised by its constitution. Okay, but I think perhaps more importantly, the case was the first, Ray Bernard's was the first case to interpret the 1862 Act in such a way as to confer that right to all companies registered under the Act. This precluded any argument by Contract Corporation or any other company that company's legislation could prohibit corporate membership, even where the company's constitution permitted it. So I'll just pause for a second just to allow you to digest that quote, and I'll pick up on some points in it. So, I mean, I'll pick up on two, perhaps 3 points, and then develop these points later. And I think in the first sentence, I mean, Lord Keynes was saying, well, he didn't seem to have an objection to this idea of corporate membership. You know, law aside, he just didn't seem to think this was problematic. I think the second point is, well, he talks about joining in trade. Okay, I'll develop this point because I think this is important. He was almost seeing this relationship as one of partnership. And finally, well, he couldn't point to a situation where the common law prohibited this. And it didn't. We've got authoritative treatises that say, well, the common law, there's nothing in the common law to prevent corporate membership. And effectively what Lord Keynes says, well, corporate membership would only be prohibited if the Companies Act 1862 so stated. Okay, but the fact was that the 1862 Act, it was silent. It didn't say anything about whether corporate membership was accepted. It just talked about persons or persons. So there's nothing in the Act to suggest that it intended persons to apply to corporate bodies. But we did have other legislation that explicitly permitted companies to be shareholders. Or Justice Keynes pointed to the Joint Stock Companies Act 1844, which explicitly, included corporate bodies within the definition of persons. Okay, so he did point to legislation, and he did have authority to support this assertion that, well, okay, because the 1862 Act consolidated earlier legislation, then this right should be implied effectively under the 1862 Act. And I think that's an important point because, well, if this first kind of true Companies Act consolidated earlier legislation, and that legislation did mention that companies could be members, I mean, it's slightly unusual that the 1862 Act didn't also. Okay, I mean, I cannot establish whether it was due to drafting oversight or whether past practice was deemed to be sufficiently entrenched to warrant not having to mention it, but I certainly don't think that was the case. I think in any event, well, neither the courts or the legislator sought to reverse or clarify the outcome of the case. But I think, well, given the immediate outcome of the decision, or the imposition of liability on a company that was deemed to be responsible for that liability, well, there would be little appetite to do so. As I said, I suppose there was probably justice achieved on the facts. Okay, we have another important decision that followed the previous year, 1868.
What was the liability?
Well, the liability would be the obligation to contribute to the assets of the new company on its insolvency.
But why? I mean, it's limited liability. What was the obligation?
Well, the shareholdings were, the way we understand limited liability.
They weren't fully paid?
They weren't fully paid.
Right.
So we've got shares that, and often what would happen is the shares would only be partly paid. So each share, for example, £50 with £5 paid up initially. So the obligation would be then to pay the £45. So there's the obligation to pay any amount unpaid on the shares.
One follow-up. I mean,
Of course.
so if the company was insolvent, like how are they going to get money out of it?
Well, I mean, I'm assuming there was some money, and the liquidator was trying to hold on to that.
Right.
There was, I suppose, they were disputing the fact that the money they had, or that was left, to be distributed to creditors. There was some money available, and that was the.
So this is the liquidator of the crown of not the new company. It's the liquidator
of contract corporations. So the corporate members liquidator was disputing this obligation to
saying
have
they
to
didn't
pay
have to pay the money out.
because it was ultra vires. It was beyond the powers of the company.
Okay, thanks.
No problem. Okay, so we've another decision the following year. So in quite quick succession, we have two cases that are establishing this right. Okay, so Lord Selwyn entirely agreed with the judgment of Lord Cairns, and he found there's not anything in the common law or statute law to prohibit corporate membership. Okay, so he said, well, although in the 1862 Act, persons continually occurred, it must be taken to include corporations. So I think what we have following those cases is a presumption that companies can now be members. Only if it could be shown that corporate membership was prohibited in the Constitution would it actually be ultra vires. So I think it was very much a matter now for the drafting of the memorandum. If the memorandum was drafted openly or in a permissive way, then there would be no issue, there'd be no problem. But I suppose the kind of emphasis in the paper is trying to look at why this approach was taken. So I think I'd like to pick up on 2 points today that I think may explain this facilitative approach of the courts. And the first one I alluded to earlier is that there was a perception that the relationship created by corporate membership was analogous to that created when a partnership was entered into. And that's a model, that's a model that the courts were very comfortable with. The second, and I think this was probably the driving factor, there was a desire by the court to ensure that companies in question could not disclaim responsibility for the shares and the obligations that came with that. And I think it was this desire that led the courts to adopt the approach to the legal question that they did. Okay, so I've termed this aspect, the first aspect of the paper, a flawed analogy with partnerships. And I think we can take from the judgment that, well, Lord Cairns appeared to view this relationship created by corporate membership as mirroring, or at least largely similar, to that created when a partnership was entered into. And I'll just bring that quote back up. And I think we can take the fact that he saw this corporate membership as being similar to partnerships from the basis of his reasoning. Okay, so the first step in his logic, that he saw the taking of one company's shares by another as akin to their entering into trade together. Okay, so one company could become a member of another as there was no apparent or prima facie objection to a company so joining with another in trade. So he saw this act of taking shares in another company as they're entering into trade. The second step was, well, as a company could enter into trade with individual, he saw no reason why a company could not enter into trade with another company. So I think this reference to trade, it indicates that he foresaw a link between corporate membership and entrepreneurship. He may have been of the opinion, although this isn't explicitly stated in the judgment, that the facilitation of conjoined enterprise between two companies would promote economic development, and a broad interpretation of the Act so as to permit corporate membership would achieve this goal. However, I think this analogy, and it was unchallenged, this analogy wasn't challenged in Re-Asiatic banking, I think it's problematic because it masks crucial differences between the two relationships. So I think, firstly, and this is important from the perspective of creditors, is there's differences in what may be termed as the accessibility of shareholders and partners to actions by creditors. Okay, so if we view, from the perspective of the two companies that are related by share ownership, what does resemble a partnership, you could say. Both companies are looking to profit, and they'll often share resources, human and financial. Okay, so the two companies related by share membership, well, you could say from their perspective, it has the hallmarks of a partnership. However, when we view this relationship from those external to the organisation, such as the company's non-contractual creditors, the relationship's markedly different, particularly with regards to the number of targets available. So I think and it's quite useful to think of this kind of visually, is when we have two people or two persons, legal or natural, joining in partnership, well, it creates a horizontal relationship whereby either partner may be held jointly and civilly liable for the debts of the partnership. The assets of both partners could be pursued if the claimant so wishes. Okay, we contrast this to a position of a shareholder. The partners, if they were natural persons, would be subject to unlimited liability for the debts of the partnership. I think conversely, when we think about the relationship that's created by corporate membership, what creates a vertical relationship. Okay, we have, owing to the protection afforded by the doctrine of limited liability, the assets of the shareholder cannot generally be pursued, only the assets of the company in which the shares are held. So I think the number of targets available to a claimant are generally reducible to one, unless there's some other remedy that the claimant could seek. I think the second kind of difference that is masked by this analogy with partnerships is that, well, in a situation of corporate membership, we have a replication of protection afforded to the corporate members, which isn't afforded to partners. Okay, so when X Limited holds shares in Y Limited, the individual shareholders of X benefit from two layers of protection. Their own assets are protected if X Limited becomes insolvent, and the assets of X Limited are protected should Y become insolvent. Okay, so in many modern corporate structures, this protection can be reproduced ad infinitum, with each shareholder at each tier benefiting from limited liability. The same issues aren't raised in the case of individual shareholders. They'll only benefit from one layer of protection. When we think about partnerships, well, if it's a natural legal partner, a natural legal person, we've seen they'll be subject to unlimited personal liability. Okay, and finally, there's a prospect of control made permissible by corporate membership that's not present in the case of a partnership. I think Lord Keynesley rightly recognised that a company could enter into partnership with an individual. But what that company couldn't do is control that person in their position as a partner. The situation is different in a case of shareholder, where the shareholder can restrict the autonomy of the other company in general meeting. Okay, so under the 1862 Act, there was a minimum of 7 shareholders required. Okay, but there was nothing to prevent one shareholder being the dominant within those 7, and then seeking to enforce its decisions in a manner similar to situations where there's a sole corporate shareholder. And I think it's interesting at this point just to draw an analogy with the position in the United States at the time, when they were acutely aware of the implications of corporate control. In the narrow sense, they were very aware of the implications where one company could control another. And they tried to prevent that. I think probably more importantly, they were more concerned about control in the wider sense, about the impact it could have on a market, on an industry. You know, this idea of preventing monopoly. So I think that was an important point just to coming across. In the English case law, in the UK case law, there was no recognition of this potential for control. It didn't even seem to be recognised or acknowledged. But in the position in the kind of late 19th century in the US, they were far, far more aware of the negative implications of control. The second point, which I think can help try to explain the reason why the court decided as they did, was the court was, I take, trying to prevent the companies from disclaiming responsibility. Okay, we see equitable undertones in the judgment on Rayburness, where Lord Cairn said, the legal obligation of the case coincides with the moral obligation, and those who are the real owners of the shares will be the persons to bear responsibility for them. So there was a kind of equitable dimension to this. The legal obligation coincides with the moral obligation. And I suppose a just outcome could be achieved in both cases by finding corporate membership to be compatible with the legislation. This would enable the liability to be imposed upon the companies in question. But I think it was this desire to achieve a just outcome. It kind of clouded the court's decision-making and reasoning. I think it led it to adopt a blinkered approach to its legal analysis and resulted in it failing to foresee the wider consequences of the decision. I think firstly the injustice which would flow from corporate membership being deemed to be ultra vires caused the court to approach the legal question with a permissive approach. It was looking for ways in which corporate membership could be deemed permissible. They didn't approach it with a kind of, asking for it to be proved. They approached it with a very positive, permissive attitude. I think this led to drawing analogy with partnerships, and then looking at legislation that did also permit it. And what the court didn't acknowledge was that we have, the Joint Stock Companies Act of 1856. It's probably the closest relative to the 1862 Act. That Act didn't say anything about companies being members. So I think the court was quite selective in the examples that it used. It didn't cite examples of very, very relevant legislation that didn't permit it. And I think maybe following the approach in the States, well, an alternative, and I think entirely legitimate approach, given the ramifications of the decision, would have been to demand permissive wording before corporate membership would have been permitted. Okay, and that's the approach that the United States adopted. Unless the statute specifically permitted corporate membership, then it was prohibited. The UK adopted the reverse approach. It was quite happy to enable it even where the legislation didn't say anything about it. And I think the second point was, well, the court just didn't consider the wider implications of the decision. There was no recognition, there was no mention of this doctrine of limited liability. There was no mention of the possibility of corporate structures emerging. And the courts didn't foresee corporate membership being used in such a way as to avoid liability, using corporate structures in a defensive manner to externalise costs. And I think, I suppose, the kind of overriding point that I kind of took from this, it's certainly arguable that it would have been preferable for the legislator to have considered the issue of corporate membership as a whole, beyond the kind of confines of these individual cases and their kind of facts that were peculiar to these cases. And I think an analogy here can be made again with the statutory conferral of limited liability. Okay, that was something, that was very significant repercussions for society. And the decision whether limited liability should be conferred was subject to a really quite significant period of digestion. It was around 20 years that this process was discussed. We had reports written on it, and then we have very, very detailed discussion of it in Parliament. Okay, so we have a 20-year period where this doctrine of limited liability was debated, discussed, very, very detailed analysis. And I think, it's certainly the same degree of analysis for corporate membership may have resulted in some of the issues which I've discussed, being raised and discussed objectively and rationally beyond the kind of confines of these cases that I've discussed. So to conclude, what I found is when the courts first found corporate membership to be compatible with companies' legislation, there was no mention of limited liability. There was no recognition that the foundation was being laid from which corporate groups would emerge. And I've argued that these were inadvertent consequences that only the implications of which only surfaced quite some significant period later. However, I think the problematic factor has been this automatic and unchecked application of these cases. Later on, these cases were used to justify the creation of parent-subsidiary relationships, where they stood for the principle that corporate membership was permissible under the Companies Act. So they then legitimised this creation of tier after tier of corporate structure. So I think, they inadvertently legitimised this and the sort of compartmentalisation of liability that comes with corporate structure. So I suppose that the concluding point was I think it's somewhat ironic that a right that was conferred to ensure that companies could not disclaim responsibility for shares is now being used and is now used in a manner which allows companies to avoid the responsibilities. So thank you very much for your time, and I'd be very grateful for any questions that you have.